phone. Okay, now, Ms. Jefferson, this is cause number 319-544. You was previously sworn in. The information in this case alleges that on or about May 28 of 2016, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Do you understand what you've been charged with? And to this charge, Ms. Jefferson, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Jefferson, I have before me a document that is titled the misdemeanor admonishments, misdemeanor plea admonishments. On page 2 of this, well, let me show you page 1. Do you recognize this document? You can stand right here. Can you see this document?
Yes, sir.
Do you recognize this document?
Yes, sir.
Okay, you can still stand there. On page 2 of the same document, did you place your initials on the line that says no contingent, which means no contest?
Yes, sir.
And on page 3 of the same document, Ms. Jefferson, above the line that's titled defendant, is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, Ms. Jefferson, do you recognize this document?
Yes, sir.
Is that your signature on the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
I have another document here. This document is titled the discovery certification. Do you recognize this document?
Yes, sir.
Is that your signature on the line that's titled defendant?
Yes, sir.
Okay, let me stand back there. Now, Ms. Jefferson, prior to signing and initialing these documents that I just mentioned, did your attorney go over these documents with you?
Yes, sir.
Did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? State, I have before me state's exhibit number 1, the misdemeanor plea admonishments. You'd like to offer states 1?
Yes, Your Honor. I'd also like to offer states 2, the probable cause affidavit in this case.
Okay. Ms. Provo, you have any objections to states 1 and 2? No objection. States exhibits 1 and 2 are admitted. Ms. Provo, you advised and counsel Ms. Jefferson. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Jefferson, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation? Ms. Jefferson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 52 days credit for time served, tax and retired court costs.
Thank you.
Ms. Jefferson, the state is offering that you serve 52 days in the Jefferson County Jail. However, you do not have to serve any more time in the Jefferson County Jail because you've already served 52 days in the Jefferson County Jail. Therefore, you'll be given credit for time served. The court cost in this case is $347, but you would not have to pay that either because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Jefferson, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes,
And do you accept the state's offer?
yes.
Okay, Ms. Jefferson, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Provo, would you please hand that to Ms. Jefferson? Ms. Jefferson, your attorney just handed you what is titled the model written admonishments on ineligibility to possess a firearm or ammunition. I will go over this document with you. In accordance with the Texas Administrative Code Section 176.1, the court hereby admonishes you of the following. Number 1, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Ms. Jefferson, that is your copy to keep. Um, You can stand on the X next to your attorney, and you're gonna follow the directions of our court clerk. And once you finish following those directions, you'll be free to go, and you have a blessed day. And I think, Ms. Probert, is this your only case?
Yes, Your Honor.
Okay, you'll be free to go after you sign, and you have a blessed day as well.
Thank you.
Ms. Jefferson, can I go ahead and get your right thumbprint on that blue light, please? Remove it and place it back down for me. So here's a copy of your commitment. You're just gonna keep it for your records and certificate. Thank you.
I'm on.
Okay, this is cause number 325-336 and cause number 327-224. Both cases are styled the state of Texas versus Tristan Killian.
We're here, Your Honor.
Um, Your name is Tristan Killian?
Yes, sir.
Okay. Mr. Killian, would you please raise your right hand?
Got it.
Mr. Killian, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
You may put your hand down. How you doing, Mr. Killian?
Good, Your Honor.
That's good. Now, the last time we was here in court, the court on its own motion, a sua sponte motion, raised the issue of incompetence to stand trial, and we conducted a informal inquiry. And based on an informal inquiry, Dr. Rapon was ordered to perform a psychological evaluation pursuant to Article 46.00B. I have a copy of the evaluation that was conducted by Dr. Rapon. State, did you get a copy?
Yes, Your Honor.
Defense, did you
Yes,
get a
sir, I
copy? And Mr. Radford, do you have any objection to the finding, conclusions, and recommendations in this evaluation?
No, sir.
State, do you have any objection to the finding, conclusion, and recommendation in this evaluation?
No objection, Your Honor.
Okay, the court is going to take judicial notice of the finding, conclusions, and recommendations in the evaluation. Hold on a minute. And let's see, my computer just went off. There we go. And based on the findings, conclusion, recommendations, Dr. Rapon, the recommendations is that he is competent to stand trial. Trying to get my monitor to work. Could you give me a copy of the information? Print me off a copy.
For both these?
Yes. In cause number 325-336, Mr. Killian, the information alleges that on or about October 17 of 2019, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of assault. Mr. Killian, do you understand what you've been charged with?
So,
Yeah, and to this charge, Mr. Killian, how do you plead? Guilty, not guilty,
Your Honor.
guilty? Now, are you pleading guilty freely and voluntarily? Okay, nobody's forcing you to plead guilty, right?
It's for my own will.
Okay. Now, Mr.
Killian.
Killian, I will At this time, also, Mr. Killian, I have before me the misdemeanor plea admonishments. Mr. Killian, he got a class, that's supposed to be an A on this. Okay, Mr. Killian, do you reckon? Okay, okay. Do you recognize that document?
Yes, Your Honor.
Tab the page to the next page. And Mr. Killian, are those your initials
Yes,
on,
sir.
on page 2 of that document?
Yes, sir.
Hit the next page.
It's always been TK.
Okay. And Mr. Killian, is that your signature above the line that's titled defendant?
Yes, Your Honor.
Okay, go to the I think it says, does it say next on there? That's another document? Yeah, okay. Now, Mr. Killian, that other document is titled the trial court certification to defendant's right of appeal. Do you recognize that document? You have to speak up.
Yes, sir.
Okay. And is that your signature at the bottom above the line that's titled defendant?
Yes.
Now, there are 2 boxes that are checked at the top of that document. The first box states that that this is a plea bargain case and you have no right of appeal. Do you understand that?
I understand that, sir.
And the second box that's checked states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Do you have the discovery
Yes, sir.
certification?
Have both of them.
Okay, just show him the first one. Will be this, the one on top. Okay, now, Mr. Killian, that document is titled the discovery certification. Do you recognize that document?
Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, Your Honor.
Now, Mr. Killian, the documents that was just shown to you, the ones that's on the paper and the ones that's on the tablet, did your attorney go over those documents with you? Yes.
Yes, sir.
Okay. And did you understand everything that he went over?
Yes, sir.
And is everything, okay, so you understood everything that he went over?
Yes,
And
sir.
everything that you just stated is true and correct to the best of your knowledge?
Yes, sir.
Okay.
And I bet you're gonna ask that the minimum for punishment.
We hadn't got there yet. We're gonna get there. Now, Mr. Killian,
Judge, do you want
skip,
that?
yeah, because I'm gonna have to get to the next document. Put it right there, okay.
Sometimes hard to predict what they're gonna say next.
Yes, just listen. Okay, now, Mr. Boyd. Let me see. Mr. Boyd, I have before me State's Exhibit number 1. You like to offer State's Exhibit number 1 as evidence in this case?
Yes, Your Honor. We have no objections.
Okay. No objection, State's Exhibit number 1 will be admitted. Now, Mr. Radford,
Yes, sir.
is there any evidence that Mr. Killian is currently mentally incompetent to stand trial?
Your Honor, he was, as the court has previously noted, he was examined very recently by Dr. Capon, and Dr. Capon, who is actually his treating physician, has found Mr. Killian competent to stand trial.
Okay, and Mr. Killian, are you satisfied with your attorney?
Yes, sir. Your Honor.
Has he provided you with, where's the building? You gotta get off the phone in the courtroom. Yeah, well, we're in a session right now. Okay, so Mr. Killian, are you satisfied with your attorney?
Yes, Your Honor.
Okay. Now, Mr. Killian, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, we have a plea bargain agreement.
Yes, Your Honor.
And what is that agreement?
1 year deferred adjudicated probation. There's no fine or community service in favor of rehabilitation efforts. Defendant also shall not communicate with the victim.
No contact.
Yes, Your Honor. Kayla Gregory.
Kayla Gregory, okay.
And then also there's order to moral recognition therapy, the MRT.
Okay,
It's a condition of probation. It's some therapy. Your Honor.
okay, MRT,
Yes,
Yes,
Your
sir.
Honor.
okay, moral recognition
I think it's recognitive.
therapy,
Yes, sir.
moral recognitive therapy is what it's called.
That's what it is.
Well, I think, well, look, it's RECONATION. I had to look it up.
Recognition, okay.
Yes, Your Honor.
Okay, now let me do this here. I think that what I may also do, may put him on a mental health caseload
Yes, sir.
with,
Yes.
with the probation so that,
If I may, Your Honor, I've already talked to Jerry Johnson, who's the head of adult probation, and he has made arrangements for some special counseling for Mr. Killian. And the court is welcome to follow up, but I've spoken with Mr. Johnson on several occasions about this, and he is aware of that and has a specialized program, I think.
right, but I just, once we, I might add that it be put on the mental health case law so that it'll be brought to everyone's attention, so he'll be given the proper treatment as, regarding his condition
Yes, sir.
while he's on probation, okay?
Yes, sir.
And so the other thing is, let me do this. Now, Mr. Killian, the state is offering
And Your Honor, I'm sorry,
Oh.
and that was to run concurrently with
Oh.
the other cause number
CC with
327-224.
224. Okay. Now, okay, now, Mr. Killian, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required you will not be ordered to pay a fine. However, there is court costs of $342 that has to be paid. Now, the probation fee in this case is $60 each month. And there's a urinalysis fee of $15 each month. The total amount that you would have to pay each month is $110. Would you be able to pay the $110 each month? He would?
His parents can pay this. Your Honor.
Well, I just need to know whether or not he can pay it, because if he can't, it's his
Yes,
responsibility.
sir.
So, let me do this. I need to ask him a few questions. Okay. Okay, I need to ask him a few questions. Is there a form up there for affidavit of indigency? It's usually, it's not a. Bruce, put your mic on mute. Okay. Now, does he receive any benefits, like
sir.
Medicaid, no
No, sir.
benefits? Okay,
He lives with his parents.
okay. Now, and he's not employed, is that correct?
That's correct, Your Honor.
Okay, so he has no income, no benefits. Okay, so he lives with his parents, so he doesn't have any expenses,
No,
is that
sir.
correct? Okay, no utility bills, no food bills, parents live with his parents. Okay, and lives with family. And what the court is going to do, the court is going to find that he is indigent. And that's pursuant to Article 42 .15 of Texas Code of Criminal Procedure. The court is going to, well, let me do this here. It's gonna be another section. Okay, and pursuant to Article 43.091, the court is going to waive the court costs in this case. 43.091. Yes. And the court and the probation fee is gonna be reduced to the minimum of $25.
Thank you, Your Honor.
And okay. Okay, now, Mr. Killian, I'll just repeat. You'll be on probation for 1 year deferred adjudicated probation. The court costs in this case of 300 and, well, there'd be no fine, and the court costs in this case of $342 will be waived, which means you will not have to pay it. And the probation fee will be the minimum of $25 per month. And there's a urinalysis fee of $15 per month. Now I think once you take that out, 25 and 15, so it looks like it's gonna be about 40.
Yes, sir.
So it's gonna be, so the total amount that would have to be paid in this case per month is $40, okay? All right, now, also, you have to participate in the moral recognition therapy program. And you'll be participating on the mental health caseload at the probation office. And you cannot have any contact with Kayla Gregory. And this case will run concurrent with cause number 327224. I see something else in here. It says, I'm just looking at the judgment, but I don't think you said it. A mental health therapy with Spindletop, mental health, was that on the paperwork? It says mental health therapy with Spindletop. Hold on, he didn't mention it in the no contact. Where you see that at? I don't, that's not on here. That's not on here. On 325. Yeah, that's not on here. Where it's listed at the bottom somewhere. No?
There it is, right here.
That's no contact.
Right.
No, I was talking about this here part that says,
Oh, MRT, that's that right there.
no, this is a moral recognition therapy. That's all it is. The mental health therapy with Spindletop mental health.
Okay, that was already on, so I can.
Well, but that was part of the that it came up naturally. Is that part of is that moral recognition through Spindletop?
I believe so. This was Ms. French had given me the note on, but it was to participate in the
Okay,
Spindletop.
because I just, he's only obligated to, the punishment is what I pronounced.
Yes, sir.
And I didn't pronounce it. You didn't mention it.
Yes.
But if it's, moral recognition therapy, the probation would know what that is, whether it's through Spindletop or whatever. So I don't think the
That's
shit
fine.
needs to be part of it because that could be something extra.
So remove that.
Yeah. Okay. Now, Mr. Killian, do you understand the state's offer? And that and the adjustments that the court has made?
Yes,
And do you think that is fair and just?
yes,
Do you accept it?
I accept it.
Okay, I'll follow the plea bargain agreement that you have made with the state with the adjustments that the court has also made. Now, Mr. Killian, we will move on to your next case. And your next case, Mr. Killian, is cause number 327224. And in this case, Mr. Killian, the information alleges that on or about January 21st of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault. Mr. Killian, do you understand what you've been charged with? And to this charge, how do you plead? Guilty?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're guilty?
Yes, sir.
Okay, now, Mr. Killian, I also have before me a document like the previous document, and you can take this here, which is titled the misdemeanor plea admonishments. Do you recognize that document?
Yes,
Okay, on page 2 of that document, Mr. Killian, are those your initials?
yes, sir.
And on page 3 of that document, is that your signature above the line that's titled defendant?
Yes, sir.
Now, on the next document, Mr. Killian, which is titled the trial court certification of defendant's right of appeal, do you recognize that document?
Yes,
And is that your signature at the bottom of that document above the line that's titled defendant?
yes, sir.
And at the top of that document, there are 2 boxes that's checked. The first box checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
I understand.
The second box that's checked states that you are waiving, which means you are giving up your right to an appeal. Do you understand that?
Yes, sir.
Okay. I also have before me a document that is titled the discovery certification. Mr. Killian, do you recognize that document?
Yes, sir.
And is that your signature above the line that's titled defendant?
Yes, sir.
Okay. Now, Mr. Killian, these documents that I just went over, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that he went over?
Yes, Your Honor.
And to the best of your knowledge, is everything in these documents true and correct?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
No objection.
No objections? State's Exhibit number 1 will be admitted. And again, Mr. Radford, is there any evidence in this case that Mr. Killian is mentally incompetent to stand trial?
I'm going to ask the court to take judicial notice of his finding in the previous case. Dr. Rapon examined Mr. Killian very recently and found him competent to stand trial.
The court will take judicial notice of the findings, conclusions, and recommendations in the psychiatric evaluation that was conducted by Dr. Rapon. Mr. Killian, are you satisfied with the representation of your attorney?
Yes, sir.
Okay. Mr. Killian, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is that agreement?
2 years deferred adjudicated probation. There's no fine or community service. And the defendant with no contact with Tangella Gage, Tongella
Tangella,
Gage, Gage.
okay,
And then also the order to the MRT, the moral recognition therapy.
okay. And this is running concurrent with,
And that's concurrent, Your Honor, with cause number 325336.
6. And in this case, the court is also gonna order that these be part of the mental health caseload.
Yes,
Your
sir.
Honor.
Okay. Now, Mr. Killian, in this case, the state is recommending that you do 2 years deferred adjudicated probation. During the 2-year probationary period, you would not be required to pay a fine. And based on the findings that the court has made previously, uh, uh, in reference to Article 43.091, the court is going to waive the court costs, in this case, which is $337. There is no probation fee in this case because he is already on probation. And however, you will be required to pay the $15 a month urinalysis fee. So the total amount of the money that you will be paying each month in this case will be the $15 for the urinalysis fee. All right? And would you be able to pay that? $15? All right. Now, also, Mr. Killian, you will be required to participate in a moral recognition therapy program with the probation department. You cannot have any contact with Tangela Gage, and you will participate in the mental health caseload with the probation office. In this case, will run concurrent with clause number 325336. Mr. Killian, do you understand the state's offer? And do you think that the state's offer in this case is fair and just?
Yes, sir.
And do you accept the state's offer? Okay, and Mr. Killian, the court is gonna follow the plea bargain recommendation, and also with the findings not the findings, but the adjustments that the court has made in reference to your court costs and as well as adding on the mental health caseload. And Mr. Killian, if you successfully complete the probationary period, these cases will be dismissed, will not appear on your record as a conviction, and you may qualify for a non-disclosure. And you can talk to your attorney about a non-disclosure. He's quite competent in these matters. Now, Mr. Killian, please stand on the X. You're gonna follow the directions of our clerk. And once you finish in here, Mr. Killian, you'll be free to go and you have a blessed day.
Judge, does he need to go to probation today?
Yes, yes. And I think this is your only case that
Yes,
you
sir.
have. You'll be free to go as well after you sign and you have a blessed day. Need to, this thing is not on. Coming on. I might have to, oh, I know why. Let me turn this off.
All right, Mr. Killian, can I go ahead and get your right thumbprint on that blue light, please? Thank you. Remove your thumb. I'm gonna need your signature on that signature pad. You won't be able to see it, but
Oh.
Judge, do you want to look at these updated ones for Mr. Killian?
Okay.
And that's for the 43.091.
Okay, you gotta put, you have to add that he's gonna be part of the mental health caseloads as a condition. Mental health caseload.
You see it?
I do. And then Mr. Radford, can I get your signature as well?
Yes, ma'am.
What exactly do you want me to write? Just list of 10?
Right here.
No, you
I
can
was,
show
I was
up.
kind of afraid.
Okay,
of
sign
saying
now.
You know,
Jeffrey.
participate in a mental health caseload.
Okay. We're gonna do that one more time. One more time. I need to get those.
We have anybody else? Mr.
No, sir, just the signature.
Who is, Martinez? Oh, okay. Okay.
So, I just need to retype it one more time to add that, mental health case load and then, I'll just have people do that after that's done.
Yeah. Yeah.
And then Mr. Radford?
Yes, ma'am, you ready?
Yes, sir.
A couple on the, are you gonna go down the docket or would you?
Yeah, actually, I was getting ready to do
Okay.
his plea.
All right.
And then we're gonna go down the document.
Okay. Have a seat and I'll, call it all when it's ready.
Philemon Martinez. He can come on. This is cause number 328772. The case is style of state of Texas versus Philemon Martinez. Is that your full name?
Yes, sir.
How you doing, Mr. Martinez?
Good.
Okay, Mr. Martinez, would you please raise your right hand? Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Martinez, you may put your hand down. Mr. Martinez, you represented here by Attorney Willard Hall. Attorney Hall, how are you doing?
Right.
That's good. Mr. Martinez, I have before me an information that alleges that on or about November 5th of 2020, while you in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Martinez, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Martinez, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Martinez, I have before me a document that is titled the Misdemeanor Plea Admonishments. Mr. Martinez, do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Martinez, are these your initials on the line that's titled guilty?
Yes, sir.
And on the next page of the same document, Mr. Martinez, is this your signature above the line that's titled defendant?
Yes, sir.
And on the next document, which is a trial court certification of defendant's right of appeal, is this your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case. And you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
May I have that discovery certification? Mr. Martinez, I also have before me a document that is titled the discovery certification. Mr. Martinez, do you recognize this document?
Yes, sir.
Is that the signature above this, on this, on the line that's titled defendant?
Yes, sir.
Ms. Martinez, these documents that I've just mentioned, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes,
And is everything in these documents true and correct
yes.
to the best of your knowledge? State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Any objections? No objections. State's Exhibit number 1 will be admitted. Mr. Hall, you've advised and counseled Mr. Martinez. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Martinez, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Martinez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. Now, Mr. Martinez, are you a U.S. citizen?
Yes, sir.
Okay. Um, uh, State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 180 days, prorated over 1 year, a $600 fine, 40 hours community service, DWI education, drug and alcohol assessment, and interlock device.
Mr. Martinez, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail for this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $600 plus court costs of $422. The total fine and court costs is $1,022. You also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. And you'll be required to pay the Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total monthly installments that you would have to pay each month is $170. Would you be able to pay the $170 each month?
Yes, sir.
Mr. Martinez, you will be required to perform 40 hours of community service, attend the DWI education class, and have a drug and alcohol assessment. And you will be required to install an interlock device on any vehicle that you own and operate. And you will also have to adhere to the standard terms and conditions of this probation. Mr. Martinez, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Mr. Martinez, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Martinez, please stand on the exit next to your attorney, and you're gonna follow the directions of a clerk. And once you're finished following the directions of the clerk, you'll be free to go and you have a blessed day. And Mr. Hall, this is your only case.
Yes, sir.
You'll be free to go as well and you have a blessed day.
Thank you.
You're welcome. cause number 328730, State of Texas versus Adam Soul. Is that your full name?
Yes, sir.
How you doing, Mr. Soul?
Good.
That's good. Mr. Soul, you're here represented by your attorney, Mr. Charles Rojas. Mr. Rojas, how you doing?
Good, Your Honor.
That's good. Mr. Rojas, you have an announcement you'd like to make in Mr. Soul's case?
Your Honor, Soul's case has been reset with the felony. The felony I thought was set for today, but I think it's already been reset to August 11th.
Okay, okay, gonna reset
August 11th?
felony, yes, it's August 11th on the docket. Okay, you can get your reset, Mr. Rojas. And, Mr. Killian, once you return to give you reset, you'll be free to go and you have a blessed day. All right. Alejandro Cruz. He can go just have a seat because I think you're the only one need to sign. Your name is Alejandro Cruz?
Yes, sir.
How you doing, Mr. Cruz?
Doing fine about yourself.
I'm doing fine. This is call number 328752. Mr. Rojas, you have an announcement you'd like to make in this case?
Mr. Cruz has been approved for pretrial diversion. I think we're set to sign that in August.
Okay, so we're gonna reset. There's always the first Thursday in August, so we're gonna set it in the second week in August.
It'll be August 9th.
Okay, we're gonna reset this for August 9th. Mr. Cruz, once you get your reset from your attorney, you'll be free to go. And you have a blessed day. Just go have a seat. He'll give you a reset in a minute. Crystal Stevenson. Crystal Stevenson. Your full name is Crystal Morgan Stevenson. How are you doing? I'm doing fine. Thanks for asking. Mr. Rojas, well, first of all, this is cause number 326434. Mr. Rojas, you have, this case is on our trial docket.
It's still a trial.
Okay, give him that, September date. for Trial. Okay, it's gonna be reset, for trial September 8th. Okay, once you get your reset from your attorney, you'll be free to go. Just have a seat and you have a blessed day. He'll give you a reset in a minute.
Here's the updated.
Okay, I'll take a look at it. Courtney Cunningham. Your name is Courtney Harris Cunningham. How you doing?
I'm good. How are you?
I'm doing fine. Mr. Rojas, what's your announcement on Ms. Cunningham case?
It's still a trial.
Okay, we're gonna put that on the set on the 8th as well. You can get your reset. The trial is set on September the 8th. And once you get your reset from your attorney, you'll be free to go and you have a blessed day. And I think this will conclude your cases, Mr. Rojas.
Yes, thank you.
You'll be free to go as well and you have a blessed day.
Thank you, Judge.
Wow. This is cause number 326-826. The case is style of State of Texas versus Felix Robert Joseph. Mr. Joseph, is that your full name?
Yes, sir.
Okay, we have Mr. Joseph here with his attorney, Mr. Don Boudreaux. Mr. Boudreaux, how you doing?
Just fine, sir.
And Mr. Joseph, how are you doing?
I'm doing all right.
That's good. Now, Mr. Boudreaux, you have an announcement you'd like to make in Mr. Joseph's case?
Yes, sir. Talk to the district attorney. They're wanting to offer the Veterans Intervention Court because of the prior issues. And I need to talk to Daniela just to make sure I understand and make sure what he'll be expected to do. Could I have a short recess, a couple of weeks or something?
Okay, that's fine.
And then we'll.
Give us a reset day. He said he need a short recess.
Announcement,
Yes.
what, a couple of weeks or?
How many weeks you need?
Say 3 weeks to be.
Okay.
And I'll dispose of it as quickly as possible.
Okay.
Whenever they have a.
August 11th? Okay, it's gonna be reset to August 11th, for announcement. Mr. Joseph, once you get your reset from your attorney, you'll be free to go. You have a blessed day. And Mr. Boudreaux, just stand over there in front of the court coordinator and she'll give you, so you get time for your reset.
Thank you, Judge. May I please?
Oh, yes, this is on the case, you may be excused and you have a blessed day. And Mr. Felix, you have a blessed day as well.
Yes, sir.
Okay.
Go ahead and sign it from Mr. John.
What are you looking for? Right, what by your hand, the first set? No, not in the back, in the front, right there.
Thank
you. What else we got? I see Bruce Cobb is on. We have,
You don't have nothing on, but you said it's a Friday.
okay, let me tell him. Bruce. Bruce Cobb. Bruce, you could take your mic off of mute.
Thing done. Okay.
Okay.
Okay, I got it off. I got it off.
Okay, I can hear you. The case that you had set for the day,
Yes.
they said it was reset to Friday at your request.
Right.
Okay.
I
so
appreciate that. I don't think I have any other cases that
No,
I
you
know
don't
of.
have, that was it.
Okay.
All right.
Okay. Am I
All
done?
right. Yes, you're done. You're free to go. You have a blessed day.
Thank you, Your Honor. Appreciate it. Have a good one.
All right. Thank you. That's three cases, 3 ones. Mr. Gertz?
Yes, Judge.
You, Roy Gonzalez?
He's here in the jury box, Judge.
Yeah, would you come forward? I think he has some warrants that.
Yeah, we're gonna have him go and satisfy that warrant. The state has made us an offer in the case, Judge, that we're not prepared to accept today, but we'll address, we'd like to ask for 60 days to address that. So we've got a bondsman on standby. So he's also to go. We need him to go to the jail. So.
Yeah, he's gonna have to go into custody. What is this warrant for? Do we know? Is it a new case or something?
No, Judge, it's the DWI involved a wreck, and there was a possession allegation.
Oh, so it just if they filed it at a different time?
Yeah, they waited until recently to file it.
Okay.
So
Okay.
even though the DWI has been on file for a long time, I'm not
I think they were
sure.
waiting on lab results to come back.
Okay. Is that the DWI? Hold on a minute.
It's the first DWI second.
Oh,
326966 is what.
so
it
he already.
stands for.
So okay. Okay, and I think in that other case, he give me some bond conditions. In that other case, he was required to have a oh, this is in 2020. Oh, never mind, I got it right here, I'm sorry. Oh. Yeah, they're right here. These are gonna be some bond conditions that he's gonna have as, now, the new offense, is that which one is the one that they filed later? Which one is it?
It's not on the docket, Your Honor.
Oh, it's not?
929486.
Oh, it's,
No,
it's not on the docket. Okay,
no, we didn't put it on the document. She has a warrant on there. I'll put it on the document.
wait up. What is that? Is that a DWI as well?
No,
That's
Judge.
the possession.
Oh, that's the
That's what we're talking
possession.
about.
Oh, that's the possession. Okay, okay. Well, okay. So, his, I guess the ones that's on the docket that he doesn't have the warrants on, we could reset those. You say 60 days?
60 days.
Okay, we'll give you time because you got a new offense coming up, that they just filed. Reset, 60 days.
Yes, ma'am.
What's the date?
915.
9/15. Okay, it's gonna be reset to September 15th, 2021. You can get, you reset Mr. Gertz and Mr. Gonzalez, you'll be taken into custody. Just follow the bailiff.
Okay, Doug, I'll see you soon. That one.
Human Day,
Judge.
cause number 329224. Is that how your name is pronounced? Human Day?
Yes, sir.
Okay, how you doing, Mr. Day?
Doing good, how are you, sir?
I'm doing fine. Mr. Gertz, you have an announcement?
Judge, we'd ask for one more announcement date, 60 days, the 9/15 date would be fine. We just got an offer from the state. We're waiting to review a couple other items of discovery.
Okay. Okay, you need to reset. Mr. Day, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Yes, sir.
Okay. You have anything else, Mr. Gertz?
No, that's it, Judge. Thank you.
Okay, you're free to go as well, and you have a blessed day.
Thanks, Judge.
Okay, we're not ready on that one. Michael Mackey,
He's sitting outside, Your Honor, we're here.
Okay.
Still
Could you-
trial. Do I need to
could-
bring him in?
yes, yes. Okay. This is cause number 325-446. Case is style, the state of Texas versus Michael Mackey. Is that your full name?
Yes.
How you doing, Mr. Mackey?
Doing all right, how you doing?
That's good. I'm doing fine as well. Mr. Mackey, you here represented by your attorney, Mr. James Mackey. Mr. Mackey, how you doing?
I'm doing wonderful, Your Honor. I disposed of 11 cases by pleas in
Wow,
the felony courts.
wow. You had a busy day.
Just filling out the paperwork was tiresome.
Okay, now, Mr. Macon, you have an announcement you'd like to make, Mr.
I
Mackey?
do, Your Honor. It's a trial. We have a pending motion to suppress the blood test results that maybe you might want to take up right before trial
Okay,
or whatever.
okay. Could you give us a trial date?
September 8th.
Okay, it's gonna be reset September 8th, 2021. Okay,
Sounds good to me, Your
I
Honor.
will get you reset. Is this your only case?
With you, Your Honor.
Okay,
Yes.
you'll be free to go and you have a blessed day. And Mr. Mackey, you'll be free to go after you get your reset and you have a blessed day as well. Okay. Are we ready on? Killing me right there. Yeah, hold on a minute. Let me call back. Call back to 2K64. Cause number 323-964, cause number 324-640. Both cases are style, state of Texas versus Oziel Carbajal. You gotta sign it, yeah. Thank you. Mr. Carbajal, your name is Oziel Carbajal? Okay. Mr. Carbajal, would you please raise your right hand? Mr. Carbajal, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yeah.
You may put your hand down. How are you doing, Mr. Carvajal?
Good, and you?
I'm doing fine, thanks for asking, Mr. Carvajal. You're here represented by your attorney, Mr. Alvin Samuel. Mr. Samuel, how are you doing?
I'm wonderful, sir. How are you?
I'm doing fine. Thanks for asking. Mr. Carvajal, the information in this case alleges that on June 23rd, on or about June 23rd of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Carvajal, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Carvajal, how do you plead? Guilty, not guilty, or no contest?
No contract?
Now, you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, Mr. Carvajal, I have before me a document that is titled the misdemeanor plea admonishments. Mr. Carvajal, do you recognize this document?
Mhm.
And Mr. Carvajal, on page 2 of this document, are these your initials on the line that's titled no contender, which means no contest?
Yes, Your Honor.
And on page 3 of the same document, Mr. Carvajal, is that your signature above the line that's titled defendant?
Yes.
On the next document, which is the trial court certification of defendant's right of appeal, Mr. Carvajal, do you recognize this document?
Yes.
Is that your signature above the line that's titled defendant?
Yes, Your Honor.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case, you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes.
And Mr. Carvajal, I have another document before me. This document is titled the discovery certification. Do you recognize this document? Is that your signature on the line that's titled defendant?
Yes, Your Honor.
Okay. Now, Mr. Carvajal, you had a
Audit
audit report. Okay. Now, Mr. Carvajal, prior to signing and initialing these documents that I've just mentioned, did your attorney go over these documents with you?
Yes.
Has to be dated.
Yes.
It has to be dated. And did you understand everything that he went over?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit number 1. And State, you like to offer State's Exhibit number 1, the misdemeanor plea admonishments?
Yes, Your Honor, and the state would also offer a State's Exhibit number 2, the probable cause affidavit.
Any objections?
No objection.
No objection. State's Exhibits number 1 and 2 are admitted. Mr. Sam, you advised in counsel, Mr. Carvajal, is there any evidence that he is currently mentally incompetent to stand trial?
No, sir, Your Honor.
Mr. Carvajal, your attorney, Mr. Samuel, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes. Very
Mis-
good.
Okay, Mr. Carvajal, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 90 days jail, probated for 1 year, $700 fine.
Is it $7, 700
Your
or
Honor.
750? I'm just looking on the,
I thought it was 7.
I was just looking on the plea information form.
I had it written down 700, Your Honor. but-
Oh, it's 700?
700, yeah.
Yes.
Okay, let me do that. So y'all have to make the change on the, on this sheet.
Yeah, do
Oh. Okay, now, Mr., well, State, would you please,
In the,
give us the offer?
the 90 days jail, probated over 1 year, Your Honor. A $700 fine, 40 hours community service, DWI education course, drug and alcohol assessment. And the other cause number, 324640 will be, is dismissed in consideration for the pleading in this case.
That is our understanding, Your Honor.
Okay. Yes.
Yes.
And the other case is clause number 324640. Is that
Yes, sir.
correct? All right. Okay. Now, Mr. Carbajal,
Yes, sir.
the state is offering that you serve 90 days in Jefferson. You got the other one? Did you do the other one out?
I'm working on it
How's the
now, but I'll
numbers?
be done.
Okay, the numbers gonna change.
For what?
Because once you go,
Oh,
the
yes,
total
yes.
amount that he has to pay for money is gonna change.
Yes, I'm almost done.
Probably gonna go down about $50, something like that.
Printing now.
Okay.
Sorry about that.
And, I'm gonna need a copy of his, affidavit of interest, too, just in case. Okay. All right. Now, Mr. Carbajal, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in Jefferson County Jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $700 plus court costs of $512. The total fine and court cost comes to $1,212. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to reimburse Jefferson County the court-appointed attorney's fees of $250 each month. You'll also be required to pay the Jefferson County DWI education class and initial evaluation fee of $125. And on the day of the plea, and should a further evaluation be needed, you'll be required to pay an additional $50. Mr. Carbajal, would you be able to pay the total monthly installments of $210 each month?
Yes.
You will? Okay. And Mr. Carbajal, you'll be required to perform 40 hours of community service, attend the DWI education class, and have a drug and alcohol assessment. And
Yeah.
you got
the
community
original-
service waived.
The original tablet didn't have community service, so I'm taking that off right now.
Oh, okay.
Yeah.
And cause number 324640 will be dismissed, and you would have to adhere to the other standard terms and conditions of probation. Mr. Carbajal, do you understand the state's offer?
Yes, Your Honor.
And do you accept the state's offer?
Yes.
And do you think that the state's offer is fair and just?
Yes.
Okay, and Mr. Carbajal, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Carbajal, you're gonna stand on the X next to your attorney, and you're gonna follow the directions of our court clerk. And once you finish following those directions, Mr. Carbajal, You'll be free to go, and you have a blessed day. And Maximo Leha. Calls number 325710. Good morning, Mr. Leha. And Mr. Samuel.
Yes, Your Honor. We have an offer in this case. We reject the offer and we're requesting to remain on the trial. I'd like to move forward with the trial.
Okay, given that September date, trial is gonna be reset to trial September 8, 2021.
September what?
8.
As soon as you pick up your refund from the.
You get your reset. Once you get your reset, Mr. Samuel, you'll be free to go.
Yes,
You
sir.
have a blessed day. And Mr. Leha, once you get your reset from your attorney, you'll be free to go and you have a blessed day as well.
Thank you, Your Honor. You too.
Okay.
Is it 10
Well-
a.m. or 9 a.m.?
She'll tell you.
Thank you.
I know it's on a Wednesday. It's probably at 10 p.m.
Am I free to go, Your Honor?
Yes.
Thank you, sir. What time?
Weldon Turner,
Yeah.
Mr. Crenshaw.
Yes, Your Honor.
Yeah. Crenshaw.
Okay, no, mine is not mine.
Usually a little longer than our local group.
Okay.
So I would ask for at least 60 days, but they may
Okay,
take-
give us a trial date.
they may take
He's
longer.
different, a little longer trial date. They got to get some blood discovered.
Okay.
And if you'll sign the discovery order, the
It could
state,
be September.
Okay, I'll take care of that later. Did you e-file it?
it's the printed form. I just got it all.
I think it got to be e-file first.
The website today.
Yeah, you e-file it and then it comes to us. It got to be e-filed. I can't just sign a motion if it's not been e-filed. That's the rules.
October 4th.
Yeah, so I'll just get that back to you so you can e-file it.
All right.
Okay. You say October 4th?
Yes.
Okay, so a trial date is going to be October 4th of 2021. Okay. And Mr. Turner,
Yes, sir.
your case has been reset for trial October 24th, October 24th, October 4th. You can get your, once you get your reset from your attorney, you'll be free to go and you have a blessed day. Just have a seat in the courtroom. And the next case. Okay. Oh, is Joseph Lewis?
He's a, wear the Texan hat.
You might have.
He just texted me and said I stepped outside.
Oh,
But he's here, Judge. He's been here all morning. And we have an agreement for the BIP program. So I was just gonna ask.
yeah, but we still gotta have him, he still gotta make his appearance. I mean.
It's fine.
Huh? Another plea is ready?
Yes, sir.
What, okay, let me look at Tristan right quick. Basically, yeah.
So for Carter Hall,
Your Honor, maybe approve.
I originally didn't put any
Hold on
community
a
service
minute.
because it wasn't on there. I went ahead and changed it, but it's still not on there. You just said it was gonna be 40 hours, so if you could just put that on there before I find.
Okay. Hold on. He went to,
Well, it's being.
no. But, Mr. Crenshaw was, had one.
Yeah, he's in the restroom, I think.
Okay,
I
we'll get back to you
My
then.
texts aren't going through, but.
Okay, we'll come back
He's
to
been
you.
out there for 2 hours.
Okay, what case, Mr. Boudreaux?
Judge, there's a lady named Blakely McLaughlin.
Is she on the docket today?
She was coming back with.
Oh, so she's not on the
there was
docket today?
some- No, there was.
Hold on. She's gonna, what, did she say Blakely McLaughlin? Give it to her so she can look it up right quick. The Glenda.
That's a case number.
Just hold on. What does she have?
It's a PWI
And,
and a violation of Texas Business Code. And that's set on the dockets for November 12th.
okay, and why are you coming forward today?
Your Honor, previously, she was on our jail docket. However, she bonded herself out and went back to Orange County.
You talking about went back to Orange
To
County, jail in
She
Orange
was
County,
picked up
okay.
in Orange County, and she's there now. She's supposed to be going to
ISF,
ISF.
but they will not send her to ISF until this is disposed of. So may I file a motion for you to get a bench warrant or whatever?
Yeah, you can file your motion.
And have her brought over.
Yeah, I mean, you,
Completed down and it's already worked out.
okay, yeah, I mean, you can file your motion.
Would that
Okay.
be all right with?
Yeah, you can file your motion and then we'll take a look at it.
Okay,
All right.
thank you, Judge.
Okay, you're welcome. Okay, who else we got?
You had a chance to look these, Judge?
Kristen, yeah, I looked at both of them.
Okay. That's weird.
That's Mr. Could we get, Mr. Freeman's clients? We got a couple of them. We got, oh, Marcus Davis? Yeah, okay. See, Donald Davis?
It's Marcus.
It's Marcus
This
Davis.
is Marcus Davis. I don't think Donald Davis is here.
Oh.
And here it is.
Who's,
Looks like they walked in.
Mr. Oh, that's his client
Yeah,
there?
that's mine. No, this is mine in the Texan shirt, Your Honor.
Okay, he can come forward.
Oh, you didn't want mine?
Well, he was, just hold on a minute.
We're putting him in the vet program, Judge, if we could have a reset for 60 days.
Okay, hold on a minute. What's his name? Oh,
Joseph Gilbert Lewis. Jr.
okay. Okay, now, Mr. Lewis, your name is Joseph Gilbert Lewis Jr.?
Yes, sir.
Is that correct?
Yes, sir.
Okay, now, Mr. Does he have bond conditions in this case?
Case number, I can't-
329574. Three two nine five seven four. Twenty-first. July 21. Okay. You could get it to your client. Hey, Mr. Lewis, you've just been handed what is titled as standard bond conditions in County Code at Law Number 2. Do you see that document?
Yes, sir.
I will go over this document with you.
Yes, sir.
And it reads, following the arrest and or accusation in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that
Yes,
condition?
sir. I do.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body, and as pursuant to the Texas Code of Criminal Procedure, Article 17.44, A2 and C2. Do you understand that condition?
Yes, sir, I do.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir, yes. The offense is my own wife, and she live in the same house.
Okay. State, do you have, he says, any objections to this condition being removed on that? I think, have you,
No objection, Your Honor.
okay, now, Mr. Okay. I need to check that one again. Okay, now, Mr. Lewis, condition number 3, this is what the court is, it's gonna be modified. It said the defendant shall not communicate either directly or indirectly with the alleged victim of the offense in a threatening or harassing manner. Do you understand that?
I understand.
Let me see, 21st day, July. Let me see that one. I could get this one to him.
I already wrote on that one. Judge. I'm sorry.
Well, yeah, okay, let me, okay. Three, 29574, Joseph, PH, Joseph Lewis. Okay. Now, Mr. Crenshaw,
Yes, sir.
his case, in reference to his case, you said that he's being put in a bid program or something?
Yes, sir.
Okay, okay. Give us a, what, does he have a sign-up date?
No, Your Honor. We just, did the form. Daniela is not in the office today.
Okay,
The form says it's 60 days is necessary for a sign-up date.
Okay.
But I would imagine, if we can't get it done by then, I'll let the court
okay, so we reset it for 60 days?
know. That's what I.
Okay. Well, give us a reset date,
9/15.
9/15 of 2021. And we'll just note for the record that this case is gonna be reset for 9/15. Also, the court has given Mr. Crenshaw permission not to have his tie. He informed the court that he had a throat irritation and therefore he was able to wear his tie. Okay?
Thank you, Your Honor.
At this time, you can get your reset. And once you get your reset, Mr. Lewis, you'll be free to go, and you'll be free to go as well, Mr. Crenshaw. Marcus Davis.
Yes, sir.
Mr. Davis, do you need to sit down?
No, sir, I'm staying.
Yeah, okay.
I need this stiff. I just had another knee replacement.
Okay,
by
okay,
the VA.
okay. Now, this is cause number 322415. The case is styled the state of Texas versus Marcus Renard Davis. Mr. Davis, would you please raise your right hand? Mr. Davis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down, Mr. Davis. How you doing, Mr. Davis?
I'm doing all right.
That's good. Mr. Davis, you're here with your attorney, Mr. Antoine Freeman. Mr. Freeman, how you doing?
Good, Judge, how are you?
I'm doing fine. Mr. Davis, the information in this case alleges that on or about February 9th of 2019, while you're in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more while you are operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Davis, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Davis, how do you plead guilty? Not guilty, no contest.
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Davis, I have before me a document that is titled the discovery, excuse me, misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Davis, is that your signature, excuse me, your initials on the line that's titled no contendere, which means
Yes,
no
sir.
contest?
Yes, sir.
And on page 3 of the same document, Mr. Davis, is that your signature above the line that's titled defendant?
Yes, sir.
And on the next document, which is titled trial court certification of defendant's right of appeal, Mr. Davis, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box check state that this is a plea bargain case and you have no right of appeal.
Yes,
Do you understand that?
Yes,
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
yes, sir.
I have another document here. This document is titled the discovery certification. Mr. Davis, do you recognize this document?
Yes, sir.
And is that your signature above the line that's titled defendant?
Yes, sir.
Now, Mr. Davis, prior to signing and initialing these documents that I've just mentioned, did your attorney, Mr. Antoine Freeman, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor, I'd also like to offer State's Exhibit number 2, the probable cause affidavit.
Mr. Freeman, you have any objections?
No objections, Your Honor.
Okay, no objections. State's Exhibits number 1 and State's Exhibit number 2 will be admitted. Mr. Freeman, you've advised and counseled Mr. Davis. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Davis, your attorney, Mr. Freeman, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Davis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 180 days, probated over 1 year, a $500 fine, no community service, DWI education course, drug and alcohol assessment, and interlock device.
Okay, Mr. Davis, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $407, which comes to a total of $907. You'll also be required to pay a probation fee of $60 each month. Give me his affidavit of interest. You also be, let's see, let me repeat this here. You'll be, during the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $407, which comes to a total of $907. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to reimburse the Jefferson County's court-appointed attorney's fees of $250. You'll also be required to pay a Jefferson County DWI education class and initial evaluation fee of $125 should a further on the day of the plea, and should a further evaluation be needed, you'll be required to pay $50, an additional $50. Now, the total monthly installments for this offense is $180 per month. Mr. Davis, would you be able to pay the $180 a month?
Yes, sir.
You'll also be required to install an interlock device on any vehicle that you own or operate, attend a DWI education class, and have an alcohol and drug assessment. The community service in this case is being waived. You will also be required to adhere to the other standard terms and conditions of probation. Mr. Davis, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Davis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Davis, just please stand on the X next to your attorney. You're gonna follow the directions of our court clerk. Once you finish following those directions, you'll be free to go, and you have a blessed day.
All right, thank you, Your Honor.
All right.
All right.
I'll have my, um, now, this is cause number 329-544. And I think this is the case that, the state had filed a motion to, revoke the bond. Am I
correct.
correct? And I think the court took it under advisement. When the court actually, after court took it under advisement, there was a request that was made, by the state, via email, asking the court to consider evidence, to consider matters, facts that wasn't in evidence. The court had an in-camera hearing regarding that matter. And based on that hearing that the court had, the court believed that it's not, that the court is impartiality can reasonably be questioned, so the court is going to recuse itself in this matter. And so the court is going to file a recusal regarding this particular case. And the court is going to request that that the administrative law judge appoint a judge to hear this matter any further. Okay, so at this point the court is going to recuse itself in this matter. Okay, so we'll be in recess. I just have to get the recusal. There's a form that the court has to sign to get it up to the administrative law judge. Okay, and so that'll be done today. And I think that once the court has stated that it's going to be recused itself, I don't think the court has any, well, we can do anything on this matter, but I'll check with the administrative law judge just to get a clarification on that in a few minutes. All right. So right now,
They
just
wasn't ready to plead to it today, Your Honor. We were just resetting it.
yeah, but I was saying the only thing is there still was an unresolved matter regarding the issue of a motion to revoke the bond. That was the issue because the court at that before the other stuff transpired, the court had announced that it would take it under advisement after having the hearing. That's my recollection.
Yes.
Okay. So at this, so just have to see, we'll be in recess for the moment. I just have to check on the matter. And is Mr. Is that your last?
No, Donald Davis.
Okay. Okay. Donald Ray Davis, cause number 329-624. Oh, okay. How you doing there, Mr. Davis? You move pretty, you move pretty fast. I looked down and was saying your name. I looked up, you was right there. Okay, Mr. Davis, do we have any bond conditions in this case? Cause number 329-624. Yeah. Okay. Okay, we're gonna that's Donald Davis. 329624. You can get it sent to your client. Okay, Mr. Davis.
Yes.
The attorney just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Mr. Davis, do you see that title?
Yes.
I will go over these conditions with you. And it reads, following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body, and that's pursuant to Texas Code of Criminal Procedure, Articles 17.44 A2 and C2. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 does not apply. That only applies in DWI cases. Now, Mr. Davis, if you fail to adhere to the conditions of this bond, your bond may be revoked, and if your bond is revoked, a warrant could be issued for your arrest. You could be put in the Jefferson County Jail. Do you understand that?
Yes.
Okay, now, Mr. Davis, you're represented here by Mr. Antoine Freeman. Mr. Freeman, you have an announcement you'd like to make in Mr. Davis' case?
Yes, Your Honor, there is a videotape that we'd like to take a look at. And
Video?
Yeah,
Okay.
we requested it. But Mr. Davis wanted me to let the court know that the alleged victim here is constantly calling him, going by his house, and he just wanted.
Stalking.
I don't know if stalking would be the word I would use, because I hadn't seen it,
Yeah.
but she is contacting me, showed me some text messages.
Well, I mean, I can't give you no legal advice on him, you as his attorney.
What, no,
But
I'm just.
Mr. Davis, I'm just telling you, adhere to those bond conditions. Your failure to adhere to those bond conditions could result in you being placed in Jefferson County Jail. Okay? All right.
And
Now,
again, he just wanted, I'm sure there wouldn't be a bond violation if she's knocking on his door. But at that particular time, he just wanted me to.
well,
let you know.
I'm just saying, well, I'm telling you right now, we're giving the bond conditions, you need to adhere to those conditions.
So,
I'm not gonna get in terms of no, this is not a hearing on
Okay.
what she's doing, and this is just some bond conditions that you have to adhere to. You have an attorney who can give you legal advice as to what you can do.
okay.
All right? All right. You can get your reset, and once you get your reset, you'll be free to go and you have a blessed day.
Okay.
And we're gonna reset him to, he needs some time to look at the video, and is that correct?
Yes.
Or to get the video, yeah.
Yeah.
Your standard reset will be fine?
I'm
30
sure,
days?
They probably have it by then.
Okay, give him 30-day reset. Set it on the, keep it on the announcement docket. And I think, August 18th, okay.
August 18th.
Yeah, you know what? I know it's coming. Y'all can stand over there and get your reset.
All we have other than the,
Okay, yeah, we'll check,
and the,
Miss, Girl, the, other cases that he have that are scheduled for bond forfeiture, we're gonna have, Miss, Jackson to check, to see if they actually received notice. Okay? And, Mr. Antoine, when you, I might have to bring you back up on Derek George, because I just remembered the process. Got a couple of lawyers. Okay, Derek George, come back up. And I just remember, I think the process is, once I announce recusal, a judge is going to be appointed, and then that judge comes on a certain date. And so your court date is going to be sent to your, yeah, it's going to be sent to your attorney. Okay, so you'll be free to go right now. Okay, all right. Okay, so your case is going to be reset. Your attorney is going to be given notice of that reset. Okay, what else we got? Oh. Yes, he is. Get Trenton Boudreaux. Mr. Charles McIntosh,
Yes, Judge.
how you doing?
Doing well, thank you.
Oh, that's good. We have Trenton Fabian Boudreaux in cause number 325676. Was DWI second. I see he was given bond conditions. Mr. Boudreaux is present in court. Your full name is Trenton Fabian Boudreaux?
Yes, sir.
How you doing, Mr. Boudreaux?
All right, how you doing?
I'm doing fine. Now, Mr. Boudreaux, your attorney, Mr. Charles McIntosh, is appearing via Zoom. That's him on the camera. Now, Mr. I see he was given bond conditions. The bond condition, I guess, DWI second, you were required to get an interlock device on your vehicle. Is that correct?
Yes.
So you don't have a vehicle. So it's any vehicle that you own or operate. Do you understand that?
Yes, sir.
All right. Now, Mr. McIntosh, do you have
Yes,
an
Judge.
announcement?
Yes, Judge. I've spoken with the state and my client today, and I believe that one more reset would probably be sufficient. If we could get it a little further out than just a normal reset, though,
Okay.
please.
Okay. How much time you need?
60 days is fine. Yes, Judge.
Okay. Give us a reset for 60. Okay, so it's going to be reset September 15th of 2021. Oh, well, let me say. Let me actually sit down. This is on the trial docket. We keeping it on the trial docket?
That's fine, Judge.
Is that a trial docket? Hold on, wait up a minute. You want to keep it on the trial docket?
September 15th works. I think that's sufficient. I'm not concerned about having it. It doesn't have to be on the trial docket for this one, Judge.
Okay. Okay, what is that? A plea? What's that?
Announcement.
Okay, it's gonna be on an announcement docket.
Okay.
Okay, reset it September 15th. You're gonna get your reset and sent to you. And once you get your reset, well, Mr. What's it? Boudreaux? Yeah, Mr. Boudreaux. Once you can stand over here on the far X, get your reset. Once you get your reset, you'll be free to go. And Mr. McIntosh, your reset will be sent to you. And you're
Thank you,
free to
Judge.
go as well. You have a blessed day.
Appreciate you, Judge. You as well.
And you have a blessed day as well, Mr. Boudreaux.
And, she's got
your attorney,
I believe they said he had some early trial.
yes, let's say I'll give him a 2-week reset. We're gonna reset your case for 2 weeks to give you your attorney. He's in trial.
Okay.
Okay, stand over there and get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
You too.
Kenneth Thibodeau,
What's your name?
his name is Brian Davis. He's number 2 on page 1.
Oh, yeah, he's on the homicide. Okay.
Yeah. Your name is Kenneth Wayne Thibodeau Jr.
Yes, sir.
How you doing, Mr. Thibodeau? I see a note here, it's supposed to be a JP reduction, but your attorney, Mr. Matuska, is in trial in another court. So we're gonna reset this case for 2 weeks. Okay, you can get your reset. You can get in line behind that gentleman. Make sure you maintain your distance. And once you get your reset, you'll be free to go and you have a blessed day. Yeah, oh well.
Yeah.
Okay. Justice Veal?
Where I'm at.
Yeah, you excused. Yeah, you excused. Free to go and you have a blessed day.
Hey, Anton.
You're in Veal case?
Yes, I'm finishing up now.
Okay.
Okay, I'm out.
This is cause number 329212. The case is style of State of Texas versus Justin Terrence Russell Veal. Is that your full name?
Yes, sir.
Uh,
Justice, Judge. Sorry.
I thought I said justice. Justice Terrence Russell Veal? Okay. How you doing, Mr. Veal? I'm doing fine. Thanks for asking. And Mr. Veal, you're here represented by your attorney, Mr. William Wilkerson. Mr. Wilkerson, how you doing?
I'm doing well, Judge.
Okay. Now, Mr. Veal, the information in this case alleges that on or about September 4th of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of marijuana. Mr. Veal, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Veal, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay. Mr. Veal, I have before me a document that is titled the misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Veal, are these your initials on a line that's titled Nola Contendere, which means no contest?
That's my initial.
And on page 3 of this same document, Mr. Veal, is that your signature above the line that's titled Defender?
Yes, it is.
And on the next document, Mr. Veal, this next document is titled Trial Court Certification of the Defender's Right of Appeal. Mr. Veal, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled Defender?
Yes, it is.
And at the top of this document, Mr. Veal, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
You have a discovery certification?
Yes, Your Honor.
Mr. Veal, I have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is that your signature on the line that's titled Defender?
Yes, it is.
Now, Mr. Veal, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, it is.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's Exhibit number 1?
Yes, Your Honor. And the
Without objection.
state would also offer State's Exhibit number 2, the probable cause affidavit.
You have any objections to State's Exhibit 1 or 2?
No, Your Honor.
Okay, no objections. State's Exhibits 1 and 2 are admitted. Mr. Wilkerson, you've advised in counsel, Mr. Veal, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Veal, your attorney, Mr. Wilkerson, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Veal, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Do we have a affidavit in this? Okay, now, State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 180 days jail, probated for 1 year.
No, sir.
Okay,
$400 fine,
okay,
60 hours community service,
okay.
drug offender class, and drug and alcohol assessment.
Okay. Okay, that drug offender class, that's that's the drug education class?
Yes, Your Honor.
Okay. Okay, Mr. Veal, the state is offering that you serve 180 days in jail. However, you would not have to serve any time in jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $400 for court costs. And, excuse me, the court cost in this case is $452. Now, the total amount of the fine and court cost is $852. Mr. Veal, do you understand? Well, Mr. Veal, you will also be required to pay a $100 fee for the crime lab, and you will be required to pay a $60 fee each month for probation and a urinalysis fee of $15 each month. Your total monthly installments, Mr. Veal, comes to a total of $155 per month. Mr. Veal, would you be able to pay the $155 per month?
For a year?
Yes,
I
each
will
month.
be able to, yeah.
You will? And Mr. Veal, you will also be required to perform 60 hours of community service, attend a DWI education class, and you would also be required to submit to a drug and alcohol assessment. Mr. Veal, do you understand? And you also be required to adhere to the other standard terms and conditions of this probation. Mr. Veal, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Veal, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Veal, please follow please stand on the X next to your attorney. You're gonna follow the directions of the clerk. And once you finish following the directions of the clerk, you'll be free to go, and you have a blessed day. And I thank Mr. Wilkerson, this is your only case.
Yes, Your Honor.
Once you have finished signing the probation form, you'll be free to go as well, and you have a blessed day.
Thank you, Judge.
Okay.
Hi, Mr. Veal. Can I go ahead and have your right thumbprint on that blue light? Thank you. You can remove your finger. And then, Mr. Veal, I'm gonna need your signature on the signature pad located in front of you. You won't be able to see it, but I will. And then, Mr. Wilkerson, can I get your signature?
Yes, ma'am.
And Mr. Veal, raise your right hand. Do you swear that you've never before been given the courtesy adjudication or regular probation for a felony or misdemeanor in this or any other state? And you have no pending charges that you're aware of? All right, you're. All right, you're just gonna report to this address as soon as you leave here. Depending on when you get there, they may close at noon for lunch, so you might just have to go when they open back up, if they're already closed. Okay. Judge, I have a question for Mr. Killian's plea that we did earlier. I haven't finalized it on the tablet yet, but I wanted to confirm something.
Okay.
So for the mental health caseload, is that referring to the four?
No, that's part of probation.
Okay, so that's gonna need to be added to the tablet. I think it was.
Yeah, I told him to add, well, that was something that wasn't agreed. That's something I added.
Right, oh, okay.
It wasn't an agreed. They agreed to one thing, but I added that as a condition from the court.
Okay.
That's why it wasn't on the tablet. You understand what I'm saying?
Yeah.
They don't agree to that. I mean, for example, the judge has conditions to add any conditions that the judge think is appropriate.
Okay.
And so even though they have a plea bargain regarding certain conditions, the judge can add something else.
So it's the 443.091.
That deals with him being indigent.
That deals with him being indigent.
And that's why I waived the court cost.
Okay. Yeah, just because anything Other than the fees being waived, it has to be on tablet. Let me check something.
Yeah,
As both of those people. that-
yeah, okay, put that on my desk, I need to,
Oh,
I'll
your
put it,
desk on
put it
the
in my chair,
Okay.
in the office. Okay,
Yeah, can you just make a note of it on the side of the plea somewhere?
make note of what?
The mental health caseload.
What do you mean, make note on the plea? What you mean?
Just since it's on my paperwork, it has to be on the tablet somewhere, unless it's like referring to the court cost waive.
I can't be,
Unless
it can't be on the tablet. I mean, that's something that okay. The form only says this is what the state and the defense agreed to. That's all that says. They don't agree to what I got in my head, and I decide to put in the thing. That's not part of the agreement. So, you know, because me putting it on the tablet is like them saying they agreed to that.
Right,
I mean, whether or not they agree to it or not, that's the order of the court.
okay.
Yeah, you can call Becky or somebody. They should understand that.
Yeah,
Yeah, I mean, this is your first time, so they're gonna have things that the court is gonna order that's not part of the agreement.
right.
So the only thing needs to be on the tablet is what they agreed to, because if there's a dispute as to what they agreed to, they can always go back to the plea form to resolve that dispute, because that's really a contract. It's a contractual agreement. One is a contractual agreement and the other one is a court order. I'm ordering that be added to the judgment.
Okay,
They're agreeing that these certain things should go in the judgment, and I order what goes into the judgment. I can order what they, agreed to, plus I can add other things to it. And then, if they don't like it, I mean,
right.
that's just the
Yeah,
conditions.
I just want to confirm so that
Yeah,
if
okay.
it is wrong or I'm not.
Yeah, I'll explain it to them now.
Yeah. Because
Okay.
one time I did a plea, I think it was for like, I don't remember what it was, but the attorney and I think it was in this courtroom, y'all had agreed on something and I didn't put it on the tablet and then,
That's totally different if they agreed to it.
yeah,
You put on the thing what they agreed to. You could say per court, you could say mental health caseload per court. And so they'll know it came from the judge. Yeah. Okay, now hold on, what we doing? Okay, hold on a minute. Okay. Okay, let me do this here. Mr. Antoine, let me